Okay?
Yes, ma'am.
It's just you have to be strong enough to make your own choices and to make your own path. Because I don't think your mom wants to see her grandbabies, if you have some someday, in that chair. I don't think you want to see them in that chair, because I'm going to be honest, I don't think your dad likes to see you in that chair. So this is a pivotal moment in your life. It's going to be pivotal where you are the one in control and you are the one who is the adult who has to make these decisions. The state made arguments that if I put you on probation, it would unduly depreciate the seriousness. Plus, you were, as I would quote, a disaster while on bond, end quote. I don't necessarily see it that way. I was here too, sitting in this chair. I was the one who was told the violations. The violation that I find to be the most atrocious is the fact that you engaged in the selling and delivery of the illegal drugs.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What you're watching unfold is not just a sentencing hearing. It's a collision between youth, loyalty, and accountability. The court is about to decide whether a 19-year-old first-time offender deserves probation or prison. On one side, a pre-sentence report suggesting low risk. On the other, prosecutors laying out a detailed web of surveillance, GPS tracking, phone data, and alleged deception. And looming over all of it, a powerful question this judge will keep circling back to. Is Charles Evans a misguided teenager, or someone already walking a dangerous criminal path?
Meaning it would make a difference if you found out something, you read something, or he read you something that you thought was incorrect?
I believe there was only one thing. It said I had a pending charge.
I don't know if I reviewed that it had a pending charge.
It did. It listed the theft as pending instead of pled to. That's what he's talking about.
All right. Okay. That makes sense. Yeah. I didn't see that it said pending, but that was one of the things that you had pled to, and that was part of your plea agreement. But thank you for bringing that out to the court's attention. And not pending, obviously. All right. Do we have any victims making any statements?
No, Your Honor.
But we are in compliance?
Yes, Your Honor.
All right. Argument and sentencing recommendation, Mr. Schmidt.
Thank you.
And I'm going to say, please make sure you cough out of the microphone, because our court reporter today is virtual. And so it may be more difficult for her to be able to hear things clearly.
I shall be cognizant of that. So I have to start with talking about the facts of this case. I think that's important because the PSI writer didn't talk very much about the burglary in the PSI's version of events. It was just like a quarter of a page. And because of what was given as Charles Evans' version of that events. So about a year and a half ago, we had a number of bar burglaries that were occurring in our area. Surveillance footage showed similar looking people doing the same thing. That is, the string was the same group of people. During that time, a friend of Charles Evans called the police to give an anonymous tip. He said that Charles Evans had told him that his dad and him were doing burglaries in the area. He indicated that Charles had told him that Chantel Bentley and Adam in particular were doing thieving in the area. The caller also indicated Adam was selling drugs. The caller indicated the exact vehicle they were using for it. He warned that they used a portable scanner to watch police traffic. And he even sent messages between himself and Charles Evans to back up claims of this, which included Charles acknowledging Adam and Chantel were stealing. When police looked at images of Charles Evans from Facebook, his face had very similar facial features to the partially masked people who were doing the burglaries. They wore lower masks so you could see the face up. The caller made specific reference to the black and orange burglary as one they did. If the court doesn't know, this burglary that Charles is being sentenced on today is the second black and orange burglary that happened in a short period of time. As a result, we got a warrant. We put a GPS on the vehicle to describe Adam Evans' vehicle. Eventually, the black and orange had its second burglary. It happened around 4 a.m, but was reported a little before 8. We checked the GPS on Adam's car. It indicated that it was at the burglary around the time it happened, that it then wandered around the area in remote locations, making a few stops, and then was heading towards Rice Lake. The GPS showed the vehicle active from midnight all the way to 8 a.m, spending that long period of time at the black and orange in those sites. Police went and followed the trail just themselves, like in person, and found at a number of these sites at remote locations, there were burned items, like somebody was burning things. They took footprints and found footprints at the burn sites matched the footprints at the black and orange. At that same time, our anonymous caller, the one who had given the tip, called and said that Charles had a falling out with Adam and they were in Rice Lake. The police took Adam into custody using the GPS to find the vehicle at the Taco John's in Rice Lake. He was still in the same GPS vehicle. It had items freshly stolen from the black and orange in it. It had numerous items of property with the names of Chantel Bentley, Adam Evans, and Charles Evans inside the vehicle. There were also burglarious tools in the vehicle. Walmart surveillance footage in Rice Lake showed Chantel Bentley and Charles Evans going in or in the parking lot. We took Charles Evans into custody largely using assistance from that anonymous caller. We were not able to take Chantel Bentley in. She got away that time. Surveillance footage at the black and orange showed 2 people entered the bar for the burglary. The bag they used was a sequin bag that was located in the vehicle Adam Evans was in. One of the vehicles was obviously a skinny female by body type. The other was a skinny male with young boyish features. As a result, neither of these people was Adam Evans because Adam Evans has a bigger, more mature frame as a person. You just look at what his build is. He obviously was not one of these 2 people. Both burglars left footprints at the scene at various places along the route as I described. One of the sets of prints that came to and from the bar were matched to the footwear that Charles Evans was wearing when he was taken into custody the same day in Rice Lake. The other did not match Adams, which would confirm it was the third person. We never did recover the footwear Chantel was wearing that day in the Rice Lake. On Charles's person was the portable scanner, like the one the anonymous caller warned the burglars would be using to avoid the police. Police tried keying in their radios to see if it was on the police frequency. It was. Additionally, call forward data from the cell phone of Charles's phone showed him at the black and orange. That's different than cell tower data. It's more precise. So it can give, rather than it's in this large triangular azimuth, it's, at this certain spot. While in jail, Adam Evans sent numerous text messages to people over the monitored line. Messages between himself and one of his girlfriends, Leanna DeMars Huser, indicates that he was asking her to keep checking CCAP if anything would show up with Charles being arrested in Burnett or Barron counties. This was before we found him and arrested him. He also wanted to know the full scope of what Charles would be arrested for. He complained that Chantel must have ran her mouth and wanted to know if she was getting the same charges as him and Charles. When we looked at Charles's phone, we found the frequent correspondence between him and Chantel Bentley. They discussed multiple times in the months leading up to the burglary, talking about going out at night and getting bread, which is slang for money, at nighttime. We also found Charles's messages to the anonymous source confirming he didn't fabricate those. The day of the burglary, Charles sent a message to somebody saying, "Yo, we gonna do this or what? I ain't trying to sit in one spot too long." The account Charles gave to the police, long after he had time to review the evidence, was that for some reason at midnight, he drove Chantel and some guy named Dale to the Black and Orange and Webster, didn't know what they were doing. Charles insisted he never left the vehicle and was on his phone the whole time they were gone, which he said was at most 20 minutes. He said they returned with a sparkly bag and a box, and he didn't ask any questions. He said they dropped off Dale and then just saw his dad down the street and picked him up. And then they drove to Rice Lake. Therefore, his account was that neither he nor his dad had anything to do with the burglary. When Travis asked him, "Why were your footprints going up to the bar then?" Charles changed his story and said he did leave the car once, but only to grab something from Chantel at the bar. Charles denied having any knowledge about the burglaries that the anonymous source indicated Charles told him about. His statement also contradicts messages he sent himself on his phone.
This is the moment where the state's case pivots from suspicion to structure. Notice what's happening here. The prosecution isn't relying on just one piece of evidence. They're stacking it. GPS data, footprints in the snow, surveillance footage, cell phone location data, text messages, and even a police scanner found on the defendant. In court, credibility matters, and contradictions matter even more. Every time Charles changes his story, the state uses physical evidence to box him in tighter. So here's the real question for viewers. When digital trails, physical evidence, and witness statements all point the same direction, how much room is left for reasonable doubt?
While on bond, both Charles and Adam were arrested for selling drugs, another claim consistent with what the anonymous caller gave. So the PSI recommends probation. The reason why the PSI recommends probation is when they input the age of this offender and his criminal history, which is none. Their system turns out the recommendation that because he's low risk and low need because of his age and lack of criminal history, he's not likely to reoffend. That's how Compass works. That's how they churn through numbers to produce those kinds of outcomes. Furthermore, when they talk to Charles's mother's side of the family, they see lots of supportive people who have good, positive peer influences on him. The problem I have with the probation recommendation is Charles has been a disaster on the court monitoring program through bond, and he's obviously not accepting responsibility. Worse, he's visibly lying to protect his father, the same person who really got him into this mess. So right off the bat, Charles is obviously not the mastermind of this case. It's clearly his father who has the criminal history of stealing and has just been in federal prison for dealing drugs on a large scale. His father is not a good role model. He has a history of using people. There were messages on the phone seemed to indicate that Charles didn't know that Chantel and Adam Evans were in a relationship, something we do know they were doing. Adam entered into a relationship with Chantel Bentley and used her for burglaries. He entered into a relationship at the same time with Leanna DeMars User and used her for dealing drugs. And he rejoined his relationship with Charles Evans after being really absent in his life for a large portion of it to also use him for thefts. Given what his convictions are for, Adam Evans, that is, and the fact that he picked up a dealer allegation while on bond, I would not be surprised if he is somehow connected to the mushrooms and THC that Charles is here having admitted to selling. I cannot fathom why Charles wants to be like his dad, is following his path, but I don't see how you can shake the conclusion that that's what's happening here. There's no other explanation that makes sense. That's why I needed to summarize the evidence of this case so the court could compare it to what the defendant's version of events are. I think his version of events shows three things. First, his lack of maturity. Only a child would think that version of events even rings as plausible. The source of the information for these burglaries was Charles himself confiding in somebody. It was confirmed in the text messages. Charles' boots were in the snow to the bar. The scanner was on his person. He was openly talking to Chantel about this stuff in the months before. The version of events that's the defendant's version in the PSI is a child fantasy designed to mitigate his own responsibility and try to protect his father, who has not pled guilty or gone to trial yet. That is why I think it reads the way it does. Second, it shows the lack of acceptance of responsibility. And this is something the PSI writer pointed out itself at the end. Just repeating the words, I accept responsibility, doesn't make it so. That doesn't mean that when you also say at the same time, you're saying, I accept responsibility, and you're saying somebody else did it. That doesn't work that way. Charles is doing the same thing we see a lot of children doing. He's playing so dumb that it becomes implausible. His account is so bad that it probably hurts him and his father's own cases more so than if he said nothing at all. Because what's his version of events? His version of events is, I just agreed at midnight to drive Chantel and some guy around and no idea what they're doing at the Black and Orange, something that I've talked to somebody else before and that I know Chantel's involving in thieving. It doesn't make any sense at all. Third and most troubling, it shows a continuing commitment to protecting his father. The single biggest criminogenic factor, if we had to pick one for Charles Evans, I would say our criminal peers and mainly his father. If Adams Evans was still in prison today for that federal drug dealing case, I don't think these burglaries happen. I think Charles graduates high school with no issue. I think he enters the real world as an adult. The court can see from the character letters of his mom and people on that side, there were a lot of positive influences for Charles. But the second his dad wandered into his life, he gravitated to that like a magnet to a lodestone. It disturbs me that Charles is still to this moment, after being in custody this long, after so many terrible things have happened to him, is still going to such lengths for his father to protect him. And I think to myself, what could a court do on probation to prevent that? Court could do no contact with Adam Evans, but how enforceable is that really? Do we really think they're never going to exchange messages or call each other or hit each other up on Facebook? There's limits to what probation can do for supervision. And that's like a big one, because I don't find it believable given all that has transpired here that Charles is going to sever contact with Adam. And the big problem with that is Adam is the cause of this person's criminal history and criminal actions. The things like the use of the portable scanner, the use of masks, using multiple people, including a getaway driver, burning stuff at the scene. These are not ideas that come to somebody who's young and has no criminal history. These are ideas taught to somebody by somebody who has knowledge and history and experience. That brings me to my recommendation. This is a young offender with no criminal history who committed the most serious of these offenses while still in high school. But he idolizes somebody who does terrible things, who has a terrible influence on him. Somebody he's forever connected to with that bond of father-son, a bond he has clearly indicated through his actions he has no interest in severing. A bond that his own family comments about in the PSI. His father is not just his father, he's a mentor and a partner in crime and the criminal justice system. My concern is if Charles Evans is still beholden to his father, this is going to continue. Thefts, burglaries, drug dealing, all the things his father can teach him as master to protege, all the things he has already taught him. I think the court has a rare opportunity here at the first conviction to do something about it. The worst thing we could do at this point would be to just do a slap on the wrist. I think that would be the lesson that Adam Evans would want Charles to learn from this at this point. That if all you do is you just say the words, I'm sorry, I accept responsibility, it won't happen again, I apologize to the victims. And the attorney says, well, he's young and he's low risk and he's accepting responsibility with a guilty plea. And really his father and Chantel were the main ones behind it. Then that's what he'll get. There's profound criminal thinking and planning at play here. If it pays off, if he gets that slap on the wrist, I think his father will be proven right. I think that's where we need to step in. The nature of these offenses, burglary, theft, selling THC and mushrooms. These offenses are all serious. People regularly go to prison for those offenses. It is rare when people do not go to prison in this county for burglary because it's such a scourge on our community, given its rural nature, its touristy nature, its property rich nature, as the county board would describe it. Probation absolutely would depreciate the gravity of the offenses. I don't think the court could do straight probation as DOC is recommending, doing probation with a state and imposed sentence. In fact, he has 240 days credit today as a result of failing on supervision on the bond monitoring the court already did. So the court's already recognized that there's difficulty with even just doing that monitoring, necessitating cash bond. This is a case where what we need to be talking about is the minimum amount of incarceration necessary to achieve the McCleary-Gallion factors, while also including a significant amount of supervision. So gravity of the offense majorly cuts against the offender here. This is a bar burglary and selling drugs in the community. This was 3 people caught red-handed on GPS, phone records, with stolen property in the vehicle, burglarizing a bar in Webster. According to the anonymous source, if we believe them, as they've been right on everything else, this is not the first time this group of people, in whatever combination, has done it before. Meaning we already have recidivism here. I mean, these 3 offenses were not related to one another. Protection of the public. This person has already failed on a level of supervision comparable or perhaps even more than what DOC is going to do. DOC wrote that they believe he's low risk based off of Compass. So they're going to be doing less than the court did on supervision with its monitoring. I think we're pretty confident in that, unless if the court specifically ordered it. The cops kept catching Charles not following conditions, even before the drug dealing. The issue with him being out after curfew hours happened almost immediately after the court waived the monitor. Quite frankly, if the drugs he was selling were more dangerous, something like heroin or fentanyl or something, or methamphetamine, we'd probably be talking about prison for that offense too. Rehabilitative needs of the offender. I don't know what to say on this. DOC writes, because there's a drug dealing conviction, there must be substance abuse issues. I don't really see it related to the other things here. He'd probably benefit from AODA, but to what extent, it's hard to say. There's an oddity in here where the court's probably caught on to it that Charles must have mental health issues. He's engaged in self-harm behaviors before. In fact, that was something that occurred after the back and forth between him and Adam Evans and Rice Lake. So there's probably something there. Again, I don't know the involvement of it. But what makes the rehabilitative needs piece looking at in terms of McCleary-Gallion difficult is, as I said before, the main criminogenic problem is the connection to Adam Evans and him being someone who can train his son and his son being willing to learn the criminal lifestyle. Adam Evans is gonna be in Charles Evans's life forever, and nothing the court can order can really stop that. It'd be nice if Charles went back to following the path of his mother and that side of the family, but that's not what we've seen for the past 2 years. To that end, a significant sentence is the only way I see of stopping that drift. I think prison has to be the answer for the burglary. The facts are too egregious, the offender is too remorseless, and I think given why he's doing this, protecting and the continuing idolization of his father, he's too likely to commit more crime. I think the compass is plainly wrong in this situation. I think it would be wild to look at the facts as I describe them and as we've seen here and come to the conclusion this person wouldn't be likely to do crime again. He literally moved to selling drugs while on bond for the burglary. drug dealing being what his father was sent to federal prison for. So he has some personal knowledge and probably feelings about it. He cannot believe, as Charles Evans cannot be led to believe, that just because of his age and lack of history, he's going to get free passes. We have to break the criminal thinking here and now, or we never will. To that end, what I would ask the court to order would be on the burglary, 2 years initial confinement, 5 years extended supervision. That's a much lower prison sentence. I usually argue for burglary, and the reason why is the age and lack of criminal history. I think the initial confinement is actually less than what DOC recommended on the state sentence. Let me confirm that. Yeah, it is. I think the court should make him immediately eligible for the challenge incarceration program. If anything is going to rehabilitate him and the criminal thinking, it will be that program. I think even more so than substance abuse, I think the challenge incarceration program, especially considering this offender's young age, there's nothing that has a better chance of rehabilitating this offender. On the THC, or should I say the possession with intent, I'd ask the court to do 4 years probation with 1 year of conditional jail. That's the max amount of probation for this offense. If I read the probation statute correctly, which says for felony, it's the max confinement period or 3 years, whichever is greater. 3 years is here. And if you're convicted of another felony at the same time, it can be increased by 1 year for each additional felony, which gets us to 4. On the theft, I wasn't sure if we were arguing that today because PSI writer wrote it as though it's pending, but we said even at the plea and sentencing, our intention is 30 days jail on that. Thank you.
Thank you. Mr. Reed?
Thank you. Thank you, Your Honor. I'm going to start off a little differently than I had planned. I am a son. I can represent to the court he was a great father. He didn't commit crimes. My brother, on the other hand, did a lot of bad things. He did a lot of bad things. We went to the same school. We had the same teachers. And my teachers didn't hold me accountable for things my brother did. My brother's a different person. Did he have influences on me? Yes. He was very, very theatrical. He was very passionate. He also did some bad things, as I indicated before. Under the statutes that we all are working under, at a sentencing, it should be narrowly tailored to the person sitting to my left, not one of his accomplices, not someone that he's related to that he'll always, as the state concedes, will always have a connection with. I start this way because I want to remind the court that we're here to sentence Charles. I know what it's like to be in a family where one person is not a good representation of the whole body. And I would remind the court as we proceed today to remember we're here to talk about a 19-year-old with no prior record. He's never been on supervision. He's a high school graduate. While he's been in the Burnett County Jail in custody, he's received support from his mother, who's right behind me, his grandmother, who's also here. He's gone to physical fitness opportunities while in the jail. He's been attending NA and AA meetings and groups in the jail, and he's been going to Bible study meetings as well. I can represent from him and from the PSI that he has a good relationship with his brothers. As the court noted, I filed 4 character reference letters in support of Charles. I would disagree with the state on Charles taking accountability, and responsibility for his actions. Charles has the right to a jury trial in these allegations. He entered a plea, and I think that that should go positively to his character, Your Honor. The state wants to make that sound as if that was calculated or that was some. He's here taking responsibility. He wants to make things better for himself, for the community, and for the victims of this crime, of these crimes. I believe under the Galleon factors and in talking with my client, making his life better is going to be utilizing his high school diploma. He has plans to try to get into trucking, to see the world, see the country, and have a job. While in high school, he completed a CNC machining class or certification. He also has a certification in welding. He's also been employed at Triple J Docks and employed at the Fishbowl. When he was working at the Fishbowl, he worked with his mother, or worked in the same place as his mother. And this, I think, shows that he can do well when given the opportunity, Your Honor. I can also represent to the court that he's been diagnosed with dyslexia and ADHD and had an IEP while in school. But in spite of some of these diagnoses, again, he completed high school and had obtained some certifications and has worked. As the PSI outlines, Charles has some mental health issues. I believe part of his probation should have a mental health assessment and some follow through with those recommendations. I also think that his probation can also assist him in job training, assisting him to moving into this job, this career of trucking, and dealing with material management and flow in the country, Your Honor. The state also talks about or discusses why prison is necessary to respond to this appropriately, Your Honor. As I stated at the beginning, there's always going to be a father-son bond here but just because Adam is his father doesn't mean that Adam will always have the kind of closeness that he's had in the recent past. I believe that Charles wants to move forward. He wants to be, being ready to use a legal pro-social. He wants to be a good person in the community. He wants to be a good person to his mother. He wants to be a good person to his family. And I believe that the PSI recommendation of placing him on probation, imposing and staying a term of supervision would be appropriate for these reasons. His rehabilitative needs are job training, mental health, criminal thinking, ways to, work on barriers with bad people in the community so that he can continue being with his family that is shown up here to support him. I believe part of his rehabilitative needs are working on his mental health. Part of his rehabilitative needs is moving away from bad influences and making better choices. He's shown through work and through school, he can succeed. Were there issues on bond, on electronic monitoring? Yes. But I think moving forward, he has the potential, and I believe that the recommendation from the PSI writer is appropriate. I think it's important to not only pay attention to the positive things in the pre-sentence investigation, for the court to see the people here in support of him. I believe that Charles is going to speak as well and make a statement to the court. But I believe he's young, and I believe that the intervention should be appropriate to him, narrowly tailored. I believe that a prison sentence at this phase would do more harm, not only to Charles, but I think it would harm the community by not overreacting, but over interventionizing this situation. I believe that probation and maybe some conditional jail would be a better, more appropriate, narrowly tailored response than a prison sentence. I would join the state in its calculation for sentence credit, Your Honor. I believe that's appropriate, or that's accurate. Thank you.
Thank you, Ms. Reed. Mr. Evans, I'm now going to give you an opportunity to make a statement if you wish. This is your only time to let me know anything you want me to know about you, about these cases. If something was said incorrectly or not as correctly and concise as you would like me to know, this is your one and only opportunity. Do you wish to make a statement here today?
Yes, ma'am.
All right, then please go ahead.
I would just like to thank you for the opportunity that you gave me when you had let me out on a signature bond to go and get my high school diploma. With all this stuff happening, you know, it's ruined a lot of opportunities, but it's only driven me harder to go and do what I would like to do. I would like to, you know, go and be able to do something that I can be proud of, my family can be proud of, and the community can also be proud of. I would like to apologize for, you know, what I have done to the community while I was out on bond, but I'm going to put that in the past. I am remorseful. I don't know how I can go and exactly show it after everything has already happened. The past is the past. I'm trying to move on and prepare for the future and benefit from the future.
What was your role?
What?
What was your role
What do you mean?
in these crimes?
Well, one of them I did, but the other one I was naive. I was being too trustworthy.
Give me specifics. Let me know if you're saying you were naive and too trusting. Give me specifics. Tell me how and why. And I truly want to know what you would do differently.
Well, I take full accountability for the intent to deliver. I was going and, you know, selling drugs. I admit that, but with the burglary, I was too trusting. I didn't go and didn't necessarily think things through, but
You knew what was happening.
to some extent,
I want you to, this is your time to be honest. And I'll let you know, I am very good at reading people's faces, hearing their words, and knowing the truth.
Yes,
even when
ma'am.
the truth isn't spoken. So I'm going to tell you right now to be extremely honest with me right now, even if it hurts your heart.
Yes, ma'am.
So tell me about that.
I guess I don't really necessarily know where to start. I mean, I could have went and did things differently, but I'm trying not to dwell on the past.
No, I need to dwell on the past. I do, because your life depends on it. I'm going to be straight up. Your life depends on me dwelling on the past and you telling me the truth about the past. The truth. And again, I'm a very good reader of people and the words that come out of their mouth, especially with looking at their expressions and their body language. You knew what was going to happen with the burglaries, correct?
Correct.
You knew exactly what you were doing when you got into the car and you drove them, correct? Again, I can read.
I wouldn't say exactly. I had some, I had suspicions. But
So that means you knew, correct?
yes.
I understand that you may want to deflect some of the responsibility. You're admitting to being accountable and being responsible for some of these actions. But here's where I need you to tell me the God's honest truth. I don't want you to try and walk me in a circle around a silo, okay? I want you to tell me the truth. because again, your life depends on it. You have 2 felonies in front of you right now that if I find it appropriate, again, based upon the totality of all of these circumstances and the arguments by each of the counsels here, you could go and sit in prison a very long time. Okay, a very long time. I believe it's 12 and a half years for the burglary. And that would be with the 7.5 years you could sit in prison. And then I'm not even going to include the misdemeanor. That's only 9 months. But with the possession with intent of THC, that's 6 years, 3 additional years you could sit. That's 10.5 years in prison that if I find this serious enough, I think you're lying to me. I don't think you're being truthful with me. You could sit a long time in prison. So now, knowing that, and again, I'm trying to be blunt and honest with you in the fact that I'm very good at my job. I'm very good at reading people and telling when they are being truthful, when they are being remorseful, and it's sincere. Okay? So, you knew what was happening those times, correct?
Yes, ma'am.
And I understand you, as you stated, you could have went somewhere else and you could have called the authorities or told someone else and tried to stop it. You were a 17-year-old kid. This is your dad. I understand those facts in that situation. But what was your part in these crimes? Start with the burglary.
I was an accomplice to the burglary.
And with what the state argued in messages that can be confirmed between not only Chantel, a co-defendant, and an anonymous source, those are all true, correct? You wrote those.
Not all of them. There was a period of time where my father didn't have a phone. So whenever we were together, he was using it to get a hold of who he needed to. But yes, to some extent, it was me, but not all of them.
But the ones that you, let's say, didn't write and you let your father write, you could read them and you knew what was said, correct?
Yes, ma'am.
So you knew everything that was happening, correct?
Yes, ma'am.
And so you were a willing accomplice, correct?
This exchange right here is the emotional core of the hearing. The judge isn't just fact-finding anymore. She's assessing character, honesty, and future risk. Judges are trained to listen beyond words, tone, hesitation, body language, consistency. When she says this is the first honesty she's seen, that's huge. It suggests everything before this moment may have hurt Charles more than helped him. At sentencing, accountability isn't just about pleading guilty. It's about owning conduct without excuses. And when a judge feels they had to extract the truth instead of receiving it freely, that can dramatically influence how much mercy is left on the table.
Yes, ma'am.
I think that's the first amount of honesty I've seen and what I've read. Is this the life you want to choose?
No.
Because you're a 17-year-old kid who could have your whole future in front of you. And I've not only read the character letters from family, but I've read the one from Ms. Onis from the Webster School. She remembers you from 4K. And then she remembers when you were at the school, and then when you left and came back. She had some pretty good things to say about you. Are those true?
Yes, ma'am.
So tell me, what else do you want me to know?
I've got plans for the future. I don't want to go and follow in my father's footsteps. I am my own person. I'm not just going to go and mirror what his actions have been. I would like to go and move forward with this and do something that I can be proud of and that will benefit me.
You love your little brothers, right?
Yes.
You want them to sit there in orange?
No.
You want them to have prison hanging over their head?
No.
And as I understand it from what I've read in the PSI, that they look up to you, don't they?
Yes.
So if you fall, they fall. Or they will look at how you fell and probably follow in your footsteps and fall in that same hole, correct?
Yes.
So you understand how extremely important it is for you to not be an orange.
Yes, ma'am.
What are you going to do about it?
I'm gonna go and, be the best me I can. I want to go and do something that I can benefit from. I want to go and do something that isn't going to keep leading me up here. I want to go and find something that I love to do and that I can keep doing and that it'll benefit me in the long run.
I hope you've realized through the course of the time that you have been in criminal trouble that just because we live in Burnett County doesn't mean that we have officers that don't know how to do their jobs. They're very, very good at that. Can you tell?
Yes, ma'am.
And can you tell with that they were able to investigate and to find more crimes that were committed, but you just weren't charged with them? You understand that?
Yes, ma'am.
So do you understand you could have a whole lot more hanging over your head?
Yes, Your Honor.
So could others. So they're good at their jobs and they get better at their jobs every day. And just because we live in Burnett County doesn't mean that we are not we may live in what people think is the boondocks, the country, but we're not podunk. People take their lives here in Burnett County very seriously. And we have people that are just as smart and just as experienced and will do all the same things that a big city will. Do you understand that if you commit a crime, you will get caught?
Yes, ma'am.
What else would you like me to know, Mr. Evans? Again, your only time to let me know anything you want me to know. Speak from the heart.
I guess I would just like you to know that I want to move on with the future. I want to again be the best me I can. I don't look very good in orange. I would not like to be in the same situation again. I've did a lot of realizing in the 7 months that I've been here, and I know that this is not what I want to do with my life. I would like to go and do something that I can be proud of, that my little brothers can be proud of, that the community can be proud of, instead of going in the same cycle that has been going on.
And I know you love your dad. Of course you love your dad. I've seen a lot of cases with children, even children who have been neglected, abused, manipulated, all of those things. They still love their parents. But now can you see the path that you want to live?
Yes, ma'am.
Are you going to be in a position where you can be strong?
Yes.
I've reviewed this pre-sentence investigation report, and I have heard the arguments of both attorneys here. And I've heard the information and statements that you want me to be aware of. This is a very serious matter. Both of them are. Well, all of them. There's more than two. All three, the three cases that you pled guilty to, all serious. Burglaries, possession with intent, you distributed and sold drugs. And I get Mr. Schmidt's argument that it was marijuana and mushrooms and those types of things. At least it wasn't heroin or anything more serious. It's all serious. It's all serious. And the fact that you said in the PSI that you were selling to make some money, that makes it worse. Because you were trying to make money off of hurting other people. because it still does hurt other people and families and their loved ones and all of those things. So it hurts more than just one person. And then the thefts, where you, again, arguably, allegedly weren't charged with a theft of a motor vehicle, but you still went to the town of Jackson, you still cut a padlock, you still stole gasoline. That's criminal thinking. And unless you're willing to change that, then you're going to be sitting in orange for many, many years to come. Is that what you want?
No, ma'am.
You have to change your habits, the things that you normally do, change your habits. You have to change your associates, the people that you hang around, you're around. And then you have to change yourself, because that's the only way you're going to significantly improve your life and make a better life. And you have to be around people that will be a positive change for you and to put you in more positive light instead of those people, even if you love them desperately and dearly, that will drag you down to the gutter. But you have to be strong enough to be able to make those choices. Again, these are serious crimes. The court has to look at the nature and the gravity of the offenses. They're serious. I have to look at your character, any past criminal record, any rehabilitative needs that you may have, or prospects that you have. I also have to look at needing to protect the public. All right. And I have to look at probation first, unless confinement is necessary to stop you from further criminal activity, to protect the public. Or if you need correctional treatment, you need treatment, you're not getting it, in the public. And the only way for me to make sure that you get the treatment that you need, the rehabilitative needs that you have, is in a facility like a prison. Or if probation would unduly depreciate the seriousness of the offenses. Okay? The state's arguing that here you look at these facts and you look at the facts that weren't present to the court prior to the arguments, but were in discovery, that you look at those facts and you look at your actual role in the burglaries and in the selling and delivering the drugs, that probation would unduly depreciate the seriousness of these offenses because they're so serious. I understand that argument. And then I have Mr. Reed's argument in where he's saying the court has to look at these other factors, these other things. Your age, you were 17 years old, you were a child, your brain is not yet formed, you're immature, that you essentially have been manipulated by your father. You are a child who loves his father and didn't have him completely present in your life the whole time, that you have the ability to rehabilitate, you have the ability to make positive changes. So I have to narrowly tailor this based upon you and what you've done and who you are, instead of holding you accountable for other people's actions and other people's conduct. I agree with that. Because that's what my job is to look at each defendant in front of me with the crimes in front of me, their past and all of those things, and say, okay, what are we looking at? What does this person need? Is this a serious enough crime where I just need to look at punishment first? Or does this person have the ability to rehabilitate and steer and veer away from criminal activity with some services and things? Or is punishment first and then look at rehabilitation? Now, if I look at these crimes and I added all of the time together of all of the charges that you were charged, the criminal charges, if you were to have went to jury trial in all of those cases, and if the jury were to find you guilty of all of those counts, it would be approximately a 35 and a half year prison sentence. 35 and a half years that could have been hanging over your head. Okay, that's a long time. And that's a combination of both in prison time and out of prison time. Long time for a 17-year-old, now 19-year-old. Long time to have to possibly sit behind bars. But with the deal that you've reached with the state, which it is a pretty good deal on your end, the maximum possible penalty you face would be that 12 and a half years for the burglary, 6 years for the possession with intent, and then the 9 months for that theft. Okay. And again, some in, some out. Maximum would be 15 and a half years initial confinement if the court were to do a maximum sentence. Again, a lot of time still hanging over your head. You have pled guilty to serious crimes. I mean, there's no ifs, ands, or buts about it. Very serious crimes. Knowing the risk, because this is, at least with the burglary, a free to argue, knowing that the state could argue and has in fact argued for immediate prison. So you knew that going in. So you are taking accountability, again, in some respects. Today, I believe, truly, I've heard the most honest statements from you, other than reading this and from anything else that has been stated, because you're admitting you knew, you fully understood what was happening. You fully understood the facts as they were occurring with the burglaries. And you, in fact, did know what you were doing when you were selling the drugs. And again, I have to look at your underdeveloped mind. I have to look at the fact that you are immature, that arguably, if we look at male versus female brains, your brain is not fully formed until 25 or 27. You have a lot of things to learn. I'm not here to diss your dad in any way, shape, or form. Not my job. But I think you understand that a lot of the things, and it's not everything. There's always good and bad in people. But a lot of the things your dad has done haven't been the greatest. They've been violations of the law. He's been to prison a few times. Not the best role model. Doesn't mean he doesn't love you. Doesn't mean you can't and you shouldn't love your dad. It just means you shouldn't follow in his footsteps. You can be better. You can be better and still love your dad. Okay?
Yes, ma'am.
It's just you have to be strong enough to make your own choices and to make your own path. Because I don't think your mom wants to see her grandbabies, if you have some someday, in that chair. I don't think you want to see them in that chair, because I'm going to be honest, I don't think your dad likes to see you in that chair. So this is a pivotal moment in your life. It's going to be pivotal where you are the one in control and you are the one who is the adult who has to make these decisions. The state made arguments that if I put you on probation, it would unduly depreciate the seriousness. Plus, you were, as I would quote, a disaster while on bond, end quote. I don't necessarily see it that way. I was here too, sitting in this chair. I was the one who was told the violations. The violation that I find to be the most atrocious is the fact that you engaged in the selling and delivery of the illegal drugs when you knew you were on bond. And I think you knew how bad that was. The other things were, in my eyes, were minimal. bond violations and with regards to your curfew, those types of things. I'm proud of you for getting your high school education. You could have said, you know what, this is too hard. I don't want to do it, and I'm not going to do it. But you pushed harder and you pushed forward and you graduated. That's something to be really proud of. Okay. And you did so with good grades. I'm not looking at a transcript with D's and, just passes. You pushed forward and hard and you got good grades and you graduated. That's telling me that you have the ability to put your mind to something and see something positive and make sure that it's accomplished. But again, you have to change your habits and change the people that you're around and change the people that you listen to. I honestly think, and I'm blunt. I'm a blunt person, and I have been blunt. I honestly think that you knew what you were doing, and you knew what your father and Chantel, what they were doing was wrong. You just didn't want to disappoint your dad. That's what I see. You can't worry about that. You have to worry about not disappointing yourself. The only one who's going to make or break your life is you. And again, it's going to be given to you on a platter. Your choice. Your choice. In looking at these charges, and I also have to look, and I have to say that I have to look at not only narrowly tailoring it to the defendant, but I also have to look at other sentences that this court has done as it relates to similar charges and things. Because I don't want to be a judge that says, I'm sending this guy to prison for 15 years for burglary, but I'm sending this guy to prison for 5 years for burglary and putting this person on probation for burglary. And I don't want to do things willy-nilly. That's not how I work. I like to be as consistent as I can with the facts that I have in front of me and the specifics about the person seated right in front of me. You don't have a criminal history. You seem to be a smart enough young man who has just made terribly bad choices, who has the potential to make different choices. And I think you have the ability to do that if you want to. With regards to the burglary of a building or a dwelling as a party to a crime, a Class F felony in 24 CF 5-1. What I'm going to do is I am going to sentence you to 3 years of initial confinement, 2 years of extended supervision, but I'm staying that. I'm putting you on probation for that charge for 4 years. With regards to 25 CF 9-3, possession with intent, THC, an H felony, I'm sentencing you to 2 years of initial confinement, 1 year of extended supervision, consecutive to 24 CF 5-1. I'm staying that. And I'm putting you on probation for 4 years. But I am ordering 1 year of conditional jail, and I'm allowing you to have that 240 days as credit towards that 1 year. So you'll have my calculation, about 3 more months to sit, to figure out your life, and to seriously figure out your direction. Because if you violate probation and you're revoked, you will have a lot of time to sit and think. A lot of time to sit and think. For 25 CF 9.3, if you are revoked, I am not making you eligible for any earned release programs. You will sit that full time. For 24 CF 5.1, I will make you eligible for the challenge incarceration program, but not the substance abuse program. I like that program, the challenge incarceration program. It definitely changes people. I have been there. I have witnessed. I have spoken with people who have went through that program and people who are going through that program. But I don't ever want to see you have to even start that program. Conditions of probation. Absolute sobriety. No use or possession of any illegal drugs, substances, or paraphernalia. Regular drug testing. For the first year, at least 2 in-person meetings with Department of Corrections. No matter where you are. If this is transferred somewhere else into Minnesota, I'm requiring it at least 2 in person for at least the first year while on probation. I'm ordering continued education or full-time employment. I want you to get your CDL if that's what you want to do. I want you to do the welding if that's what you want to do. And I think you said something sometime, or maybe I messed this up with somebody else, about cooking. You like to cook. I want you to do something to better your life. You are ordered also as a condition to have a mental health assessment and follow through until you must complete all of the follow through. You are also ordered to have a therapy assessment if that's not included in the mental health assessment, and to have therapy, trauma-related therapy. And that is until either your therapist or Department of Corrections agent determines that you can stop. I am ordering that as a condition of probation that you complete the alternative to incarceration program with restorative justice, as well as the skills directed practice program. And they must be completed separately. I am ordering that you cooperate with the state and you testify honestly at trial if you are required to do so. At this time, no contact with your father, Adam Evans, unless approved by your Department of Correction agent, and not until his case is fully resolved. No contact with Chantel Bentley unless approved by the court or your Department of Corrections agent. No contact with anyone on felony probation or extended supervision as it relates to any felony that is H or higher. As it relates to the theft charge, I am ordering the 30 days of jail time served. You have 240 days of jail credit. That credit can be used not only for your conditional jail, but for that theft as well. $518 for each felony for fines and fees. With regards to the misdemeanor, $443. As a condition of probation, you must make payments of at least $100 per month. Failing to follow any of these conditions of probation means you could be revoked and you could be sent to prison. Huge, huge stick over your head to determine, it could come back and hurt you, but that would be you making those decisions and those choices. The court, although again, understands that this is very serious, I do not believe that probation, if I put you on probation, it would unduly depreciate the seriousness of the offense, because I believe your rehabilitative needs with your age, your mental health, your mental cognitive awareness, and maturity, those things the court views as primary in looking at this sentence. I believe that I send a 19-year-old to prison. You're not just a 19-year-old, I've sent them to prison before. This 19-year-old, based upon your facts and based upon who you are as a person, what I've learned about you, all of those things, it would do more harm than good. It would teach you more wrong than it would good. And I believe you would learn how to be a better criminal, and that's not what I want. And I really, truly hope that's not what you want. I see good in you, Mr. Evans. I see good. And I want you to show not only Burnett County, but the world, all of your good. And I'm giving you that chance. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I forgot an AODA assessment as a condition. Failing to pay fines and fees not only means the court will enter a civil judgment against you because you'll always owe them, but you could sit up to 6 months and I will issue a warrant. These fines and fees will be paid to probation. So make sure you pay probation, but they will notify the court if you're not paying. I believe I have covered everything, except that as it relates to the restorative justice alternative to incarceration and skills-directed practice, those must be done within the first 6 months of your probation after you're released from custody. Mr. Schmidt, am I missing something?
Maybe I missed it. Did the court order no contact with Chantel Bentley?
Yes.
Okay, good.
Mr. Reed, am I missing anything?
Just a couple of clarifying questions, Your Honor. As to the theft, the 25 CM 98, is it the court's intention for the 30 days to be concurrent to the...
Concurrent to conditional jail.
Yes, Your Honor. And my only other clarifying question, as to the AODA assessment and follow through and the mental health assessment and follow through, the court ordered no contact with people or individuals with that H felony or above. Is there a way the court could...
Unless approved by agent.
Okay. Oh, so if the follow through, if there's someone in the group with a felony, that's okay.
Yes.
Okay,
The
that was
agent
my,
will approve.
okay, that was my only concern. Okay, thank you, Your Honor.
Nothing else?
No, Your Honor.
All right. Then we are adjourned. All right.
This exchange right here is the emotional core of the hearing. The judge isn't just fact-finding anymore. She's assessing character, honesty, and future risk. Judges are trained to listen beyond words, tone, hesitation, body language, consistency. When she says this is the first honesty she's seen, that's huge. It suggests everything before this moment may have hurt Charles more than helped him. At sentencing, accountability isn't just about pleading guilty. It's about owning conduct without excuses. And when a judge feels they had to extract the truth instead of receiving it freely, that can dramatically influence how much mercy is left on the table.